in the LifeLong Links series. Our presentation this morning is Deanna Klingon-Fisher, our State Long-Term Care Ombudsman. A few housekeeping items before we get started. We are recording this presentation this morning. If you have any questions, we encourage you to type them in as we go along, and we're going to address the questions at the end of the presentation. So I want to thank you again for joining us, and now I'm going to go ahead and turn it over to Deanna.
Wonderful. Thank you so much. Good morning. Happy Friday, everyone. It's nice to be with all of you to have a conversation about the Ombudsman program and some of the issues that we see and encounter, but I think actually I'll save a lot of the issue conversation for another webinar I believe we have set for the 29th, so stay tuned. I'll just tantalize you a little bit to begin with. But for those of you who don't know me, I know Nicole introduced me. I'm Deanna Klingon-Fisher. I'm the State Long-Term Care Ombudsman. However, in case you aren't aware of it, I have been with the Department on Aging for 24 years. The role that I held previous to this position was Legal Services Developer, and as such I worked with issues of guardianship, conservatorship, powers of attorney, representative payee, end-of-life care issues. And while in that role, I also worked with issues such as elder abuse, neglect, financial exploitation. And I give you that background because I feel like it's been beneficial for me to have experience in those issues and those concepts in this role as the State Ombudsman. Certainly we encounter those issues on a regular basis, if not daily basis, pardon me, and it's helpful to know where to turn and where to reach out to in that sense. Our time together, we're going to have an hour. I do certainly welcome your questions, and my goal always when I give a presentation is to be available to answer your questions, have a discussion and dialogue with you so that your questions can be answered by the end of this session together. Certainly I have material I can present, but my main goal is really not to talk at you, but really to engage you in a dialogue and a conversation. So if you do have questions, please feel free to type them and we will get to them. If for some reason a question that you raise is something I'm going to be addressing a little bit down the road in some of my slides, I will defer on that question. But again, if at the end your question hasn't been answered to your satisfaction, I will, if we have time left, I will attempt to answer that a little bit better for you, or I'm always available through email or by giving me a call. So just keep that in mind. All right, well, without further delay or ado, let's get started on the Iowa's program. In particular, I'm going to be talking about the Iowa Long-Term Care Ombudsman program. As many of you may, or I guess may not be aware, the Older Americans Act requires each state to have a long-term care ombudsman program. Because the Older Americans Act requires each state to have an ombudsman program doesn't mean that they're the same in every state. So if you are working in a county that borders another state, it might be very beneficial for you to contact that other ombudsman program to find out exactly how that program works. For instance, Illinois' program, although they are advocates, we are all advocates for residents in long-term care facilities, the Illinois program does not actually reach out or serve individuals that are 60 or young, I should say younger than 60. So those individuals who might be in a facility that are 59 under are not reached by the Ombudsman program in Illinois. As an example, each state runs their program a little bit differently. So while we are required and mandated to have a program across all the 50 states and territories, they do operate a little bit differently. So my perspective today is going to be to share with you how we do things in Iowa, which I think would be most beneficial since we all reside in Iowa. So let's see if I can maneuver this PowerPoint now. Aha. So I like to start out certainly one of my first roles, or my first lessons when I began this role, was to learn how to pronounce ombudsman, because it is kind of a complicated word, and people do fumble around with it. I tell people, you know what, just try to say it as best you can. If you get anywhere close, we will respond. We know that you're trying to reach us. But what I've done here on this slide is really put hyphens between, I think, the points of emphasis. So if you really are wanting to know how to appropriately state the word, you will learn so by this hyphenation. So it's really broken down into three components: ombudsman. I have heard some say ombudsman. So either one is acceptable, or actually, like I said, anything close is acceptable. But what is an ombudsman? What does that mean? Well, the origin is from Sweden, and it means that it's a public official who's appointed to investigate citizens' complaints. And it could be against local or national government agencies. In particular, those that are infringing on the rights of individuals. So the original concept of an ombudsman was to investigate citizens' complaints against their government, and in particular when they felt their government was infringing on their rights. The ombudsman definition today is really multiple-fold. And we do have multiple ombudsmen across the nation, not only for long-term care, but for other issues. For example, there is an ombudsman that's a government official who hears and investigates complaints by private citizens against other officials or government agencies. That could be the formerly known as Citizens Aid Ombudsman, which is now just called the Ombudsman's Office. There are also Medicare ombudsmen to help Medicare beneficiaries who are having concerns with the Medicare program. There's also a person who investigates and attempts to resolve complaints and problems between employees and employers, or between students and universities, and in particular the Regents universities. They call themselves ombuds, and they are there as an advocate for the student or for the employee. Of course, today we're not here to talk about those types of ombudsmen. We're here to talk about the long-term care ombudsman, and that leads us into the discussion of what is the long-term care ombudsman. By definition in the Older Americans Act, we are an entity that identifies, investigates, and resolves complaints made by or on behalf of residents of long-term care facilities. And I've given you our phone number. It's a toll-free number in the event that you encounter someone who has a concern for someone who is residing in long-term care, as well as perhaps maybe they feel that this individual needs to be moving into long-term care, and they'd really like to talk to someone about their options. We do not necessarily make recommendations of specific facilities, but we can walk people through the process of how they can come up with their own ideas as to which facility might be most appropriate for them or for their family member. Again, the ombudsman, we identify, investigate, and resolve complaints made by or on behalf of residents in long-term care facilities. So you might be asking, what's a long-term care facility? The Older Americans Act defines that for us, and it says that a long-term care facility is any skilled nursing facility, any nursing facility, a boarding care facility, or any other adult care home. And that includes, in Iowa, how we've used that terminology is we include assisted living facilities or programs and elder group homes. So that's federal law. Then we look at state law. State law defines a long-term care facility as a long-term care unit of a hospital or a facility licensed under 135C, which is the regulatory entity for DIA, or Department of Inspections and Appeals. And that facility can be public or private. So further looking at that definition, it means it's a residential care facility a nursing facility, an intermediate care facility for persons with mental illness, or an intermediate care facility, also known as ICF, if you hear that terminology, for persons with, the law used to say mental retardation, and it's recently changed to intellectual disability. So if you hear of that terminology, that's how a healthcare facility is defined in Iowa. At the present, I will let you know, the Iowa Long-Term Care Ombudsman Program will go in and investigate concerns and complaints for residential care facilities, for nursing facilities, for long-term care wings in hospitals, as well as then assisted living programs and elder group homes. We work collaboratively with many players, but I wanted you to know off the cuff, because this definition includes ICF ID, or intellectual disability, and ICF MI, or mental illness, we do not go into those facilities. And the reason we do not go into those facilities is that it is specifically exempted in our part of the provision. So in Iowa Code 231, there is an exemption that says that the Ombudsman's program does not go into facilities that primarily care for persons with mental illness or have intellectual disabilities. If those individuals are within nursing facilities, residential care facilities, we certainly advocate for them. We are their advocate, but we do not advocate for individuals that are in these specific facilities. So you might ask, who's their advocate? Their advocate is DRI, Disability Rights Iowa, who is the protection and advocacy entity in the state of Iowa. So I just wanted to give you a little bit of information about that, and I don't necessarily expect you to remember it always, but I do like to tell people, you know, if you have a concern, if you have someone that has a concern and you're just looking for a resource, certainly you can have that person call us. We're not going to say, sorry, we don't help you, but we will actually refer that person to the appropriate entity. So I just wanted to give you a little bit of information. The Long-Term Care Ombudsman handles residential care facility, nursing facility, the skilled wings, long-term care unit wings of a hospital, assisted living, and elder group homes. And we do serve anyone that resides in that home or in that facility. They don't have to be 60 or over. So who are we? I've kind of given you a little bit of this already, but a long-term care ombudsman is an advocate. We're an advocate for residents of licensed care and assisted living programs. We ensure that the rights of residents and tenants in long-term care settings are honored and respected. That is our main goal, advocacy and ensuring rights. I threw in there, you'll note, I threw in there tenants of assisted living, because how Iowa's law works is that residents of long-term care facilities have some federally mandated and state mandated rights, whereas persons that reside in assisted living and elder group homes have different levels of rights, and in fact in Iowa the landlord-tenant law applies to them. They do not have specific federally mandated rights. People residing in assisted living and elder group homes are called tenants, and therefore the landlord-tenant law applies. People residing in residential care facilities and nursing facilities are called residents. Therefore, the rights conveyed by federal and state law for residents apply. Of course, the ombudsmen aren't the only players in the game. We have other individuals that we work collaboratively with, hopefully, and in some cases we do need to take on, and that's not in a mean way necessarily, but if we find that one of the players is not actually acting in a manner that helps protect the rights of residents, we do pursue that on behalf of the resident or tenant. So two of the players that specifically I want to talk about are the Department of Inspections and Appeals, or DIA, and Disability Rights Iowa, or DRI. And of course our world is acronyms, so I've spelled it out for you in the event you don't know that acronym already. DIA is the regulator of long-term care facilities, assisted living programs, and elder group homes, as well as hospitals. If you have a concern that you feel, or someone brings to your attention a concern that you feel rises to the level of a violation of law or rule, then it would be very appropriate to make that referral directly to DIA. Our office certainly works on behalf as an advocate for residents. If we encounter violations of law, we certainly can work with the facility to remedy and rectify that situation, but the hammer in that sense is DIA, because they are the ones that license the facilities, and if there is a violation of law, that can impact the facility's license. So they're a good resource to be aware of. If we get involved in a case and we do realize that it has violated law or a right that rises to the level of a violation of law, we also involve DIA in that with permission of the resident or tenant. There's also Disability Rights Iowa. So they are an advocate for residents with mental illness, intellectual, and other disabilities. And as I mentioned previously, they also are the advocate for individuals who reside in facilities that are primarily serving people who have a mental illness or an intellectual or other disability. So if you encounter, or someone calls you and they are encountering situations for people in that type of a facility, another good resource is Disability Rights Iowa. And we've collaborated and partnered with them in multiple such situations. For instance, in a facility where someone has a guardian and we don't feel like the guardian is acting in the best interest of the resident or the ward in that sense, Disability Rights Iowa has attorneys that can come in and represent the resident. So what are the functions of the Long-Term Care Ombudsman? These are straight out of the Older Americans Act. You will note that the Older Americans Act, I kind of alluded to this multiple times, but the Older Americans Act is very distinctly resident-based or focused. There is little discussion in the Older Americans Act about assisted living and elder group homes or other less restrictive types of setting for people to live in. So what I'm going to read to you talks about residents here. These relate to people that are in nursing facilities, residential care facilities. However, as just a point of practice, our office also confers these to residents or tenants in assisted living as well. So the functions: we identify, we investigate, and we resolve complaints made by or on behalf of residents. It doesn't matter, in our mind, it doesn't matter if that complaint rises to a level of violation of law or rule. Our goal is to ensure the satisfaction of the resident who's residing in that facility. It could be that as an example, it could be that they just are not liking the food choices that are presented and prepared to them. It may be that the facility is very compliant with every law. They're preparing that food exactly the way it should be. It's at the right temperature, so there's no violation of law. But it does impact the residents' quality of life. You know, in some situations, they look forward to their lunch or their meals, and if they are not adequate or meeting their wishes, that's a concern, and that impacts their quality of life. Certainly that is something that the Ombudsman's office would take on and look into and try to resolve for that resident with their permission. So we identify, investigate, and resolve complaints made by or on behalf of residents. We also provide information to residents about long-term care services. It may be that individuals, they don't want to really file a complaint, but they want to know if something's a legitimate practice. Or it could be that family members are interested in understanding, you know, can the facility do this or can they not do this? Or what are some questions we should be asking before we actually admit our family member to a facility? That's the kind of thing I'm talking about here. We provide information. We ensure that residents have regular and timely access to services through our office. So one of the mandates is that an ombudsman is available to meet with a resident if they choose to contact us or reach out. And in some cases, what happens is a family member is the one that contacts us. The family member is not our client. Although we take those complaints and concerns very seriously, in order for us to pursue that, we then need to go and meet with the resident and talk with them to say, is this something you're also concerned with? We don't necessarily share the complainant's name or the person's name that's called us unless they give us permission. But we do want to talk with the resident at any point we get a complaint to say, is this something that you're concerned about as well? Or are you perfectly satisfied with how things are going for you? If the resident says they're happy with how things are going, at that point, the issue ceases for us. And we always, of course, give them our contact information and say, if at some point that changes for you or something else occurs and you really do want some help in resolving this issue, please call us. So it's always important to remember that the focus for the Ombudsman program is that resident or the tenant. It's not necessarily the person who's calling us with the complaint. Although we take them seriously, our client is the resident. We also represent the interests of residents before governmental agencies. So it could be a Medicaid appeal, it could be a discharge issue. If the facility is trying to discharge them and they want to appeal that process before an administrative law judge, we can assist them if, again, they give us permission. We seek administrative, legal, and other remedies to protect the health, safety, welfare, and rights of the resident. We analyze, comment on, and monitor the development and implementation of federal, state, and local laws. So what are the proposals out there for both state and federal laws as well as administrative rules that might impact people in facilities, whether that's a good impact or a bad impact? In fact, our office has made comments on administrative rules where we feel that the administrative rule will negatively impact that resident and their choices and their rights. We promote development of citizen organizations and resident and family councils. Each nursing facility, residential care facility has the ability to have a resident council that is spearheaded by residents, not by the facility. So if a resident contacts us with an interest in establishing a council, or a family member contacts us with an interest in creating a family council, we work with them to help that happen. We give them resources. We can even attend if we are invited so that we can help them with the organization process of that council. Again, we find that many times those councils are very beneficial for the residents as well as the family members because it brings like-minded and like-situated people together so that they can have conversations with other individuals and share experiences or frustrations that they're having. We educate and inform, like I'm doing today. We educate people as to what is the Long-Term Care Ombudsman, what can we do, what can't we do, and certainly we talk about laws, rules, regulations, policies that impact the people we're here to serve. We also always advocate for changes to improve the residents' quality of life and care. If you remember nothing else from this presentation, remember that we are advocates for the residents and tenants who are here to serve. I, of course, hope you do remember other things. I'm not suggesting that that's all you remember. All right, so let's talk briefly about the structure of the Iowa's program. We have state and local long-term care ombudsmen. The Office of the State Long-Term Care Ombudsman designates local long-term care ombudsmen, and we're fortunate enough in this state to have many different players in our program. Certainly, we have the State Long-Term Care Ombudsman, which is me. There are 8 local long-term care ombudsmen who serve a region, and I've got the map a little bit later so you can look to see who your local long-term care ombudsman is. We have 2 certified volunteer ombudsman coordinators. We have 1 discharge specialist position that we are in the process of hiring for, and I'm hopeful that they will start sometime in September. We also have Karen Risch, who is a VISTA volunteer / employee. She's not really a volunteer per se, but she is here with us from the VISTA program to help with the Volunteer Ombudsman program specifically in recruiting and training and gearing up that program so that we can, in fact, have volunteers in all of the nursing facilities across the state, which is about 451. We feel like we're getting a good start, and I'll talk a lot more about the volunteer program in a few minutes, but we have 93 certified volunteers at this point, and that's quite, it's quite a task to undertake to certify a volunteer, and it takes quite a commitment for the volunteer themselves. So we're very proud of the fact that at this point we have 93 certified volunteers, but of course we're always looking for more, and hence Karen's role in helping us recruit and market the fact that we have a volunteer opportunity for people within the state. All right, we have an administrative assistant, Katie Mulford, and so if you called here, you probably more than likely would be able to talk to Katie if you're looking for one of us. And one secretary who works specifically, primarily with the Volunteer Ombudsman Program, Pat Wyatt. I alluded to, when I was talking about Karen, as well as the volunteers in general, we do have a Certified Volunteer Program. We call that program VOP, or because it's such a long acronym or wording in the Code of Iowa, we've shortened it to just VOP, or Volunteer Ombudsman Program. That program became effective July 1st of 2012. So it's a relatively baby program. And that's why I said we're really thrilled with the fact that we have 93 volunteers who have made the commitment to go through the certification process. That law in 2012 allowed the department to develop the Certified Volunteer Program. It actually added new language to the Code of Iowa, 231.45, which states and mandates that we establish a certified volunteer program, and it set out the criteria for the certification process. Certainly now volunteers need to go through a background check, and they need to go through on-site training and orientation. They go through training with our volunteer coordinators, and then we also require continuing education, 10 hours a year after that, to actually be recertified. So it is a continual learning process, and we feel that that benefits the residents, of course, but it also benefits the volunteers who are not left out there trying to figure out what is my role, what can I do, what can't I do. We have the coordinators who serve as support and can provide technical assistance to all of those volunteers. The two coordinators, you'll notice on the listing, I didn't mention them, but Maria Bentrott was the person that was brought on in 2012 when the legislature gave us additional funding to transition from the Resident Advocate Committee program to the Volunteer Ombudsman program. So she started out first, and then a year later we were successful in selling the need to legislators, and they gave us another position to really be that volunteer manager component, and that was Sarah Hinsman. So we now have at this point 2 volunteer ombudsman coordinators that are working with our volunteer program. The local long-term care ombudsman I mentioned, certainly we have 8 of them, and we are very fortunate to have 8. Of course, we would always prefer more because, as you can see from some of this map and these graphics, that many of them cover many counties, and in fact it's very difficult at times to ensure access to an ombudsman when you're covering 6,665 beds or people. Unfortunately, we really at this point focus a lot on the complaint. We're more complaint driven at this point. We respond if a call comes in and someone has a concern or a complaint. That goes to the top of our pile, our triage. What we would love to be able to do with the volunteers, as well as then with perhaps additional local long-term care ombudsmen, is to be available to respond to needs without being complaint driven. and to be able to perhaps just drop into a facility at some point to check on how things are going rather than just popping into a facility if there's a complaint. So you'll notice I give you this map, and I believe you can print this off, but if you find that you can't print this map, the PowerPoint off, or you'd like a bigger map, I'd be happy to email that to you. So just send me an email. I believe my contact information is at the back of the PowerPoint, and I'll send you this map. But you'll see, for instance, if you're in Lyon County, Kim Weaver is the local long-term care ombudsman. If you would receive a call or a concern or complaint from a resident, a tenant, a family member, friend, a facility member, facility staff person, feel free to refer that directly to the local ombudsman. Because if you called me, that's what I would do. I would, in essence, get that to the local ombudsman. They will go out and meet with the resident. They will look into the records. They will figure out what's going on. If they feel that there is something that needs perhaps policy change, rule change, they involve me so I can work on the systemic advocacy piece of it. But the day-to-day handling of complaints is done by the local ombudsman. You'll see in the southwest part of the state, it's Julie Pollack. North Central is Stacia Timmer. The area surrounding Polk County or Des Moines is Melanie Kempf. Polk County and kind of down into southeast is Tanya Amos. Northeast Iowa is Jennifer Gawley. Kind of the south central southeast Iowa area then by Cedar Rapids is Pam Relsbach. And then the eastern part of the state is Kim Cooper. And their phone numbers are given on this slide, so feel free to call them directly if you have concerns that arise in that area. So what are our mandates? Certainly everything we do is a mandate, but specifically what I wanted to point out here is that the Older Americans Act and Iowa law give us access to a long-term care facility and to residents. A facility cannot bar our entrance into the facility. We have the right to meet with residents as long as the resident is willing to meet with us. So a facility or a program cannot say, you cannot come in here to meet with these residents. They're sleeping, they're eating. We have the ability to access the facility 24/7. If they give us grief on that, then that's a violation of, and that's called interference, and they can be fined and cited for that. We also have access to review medical and social records without limitation. We have access to the same administrative records, policies, and documents that a resident would have access to. We can access and on request make copies of all licensing and certification records maintained by the state with respect to the long-term care facility. Someone has a complaint or a concern, I always like to tell people that is confidential. That information is confidential, and in fact at some points can be, so that person can remain anonymous. Certainly we like to get names just from the perspective of if we investigate a complaint and we feel there's more to it or we need more information. If the anonymous caller doesn't give us any type of contact information, we don't know who to follow up with on that. But again, we would rather hear about the information if there is a concern. So we're not so concerned about getting names, but only in those rare instances where we might need more information, it would be helpful to have a name. Pardon me. So the identity of the complainant or the resident remains confidential unless they give us permission to release that information and they sign a release. I mentioned the non-interference. Certainly the state shall ensure that willful interference with representatives of our office shall be unlawful. Representatives of our office include me as the state ombudsman, the local ombudsman, the volunteer coordinators, and all of our certified volunteers. We prepare an annual report that gets submitted to the governor's office as well as each and every legislator. The annual report is on the department's website, which I prepare annually. It talks about what we've done throughout the year. What are the types of concerns that have come forth? How many complaints have we received? How many cases have we opened? What are we doing with the funding that we receive, as well as what are we doing on behalf of the residents we're here to serve? It also says we will develop a program for unpaid volunteers. We are doing that through the Volunteer Ombudsman program, and that we will coordinate with the protection and advocacy entity in Iowa, and that entity in Iowa is Disability Rights Iowa. So part of our role, well, a big part, not just a big part of what we do is advocating for residents' rights and tenants' rights. So in order to be able to make a referral based on rights, I thought it might be beneficial for you to hear what those rights are. And I think it's always important to remember that just because I'm a resident in a long-term care facility now doesn't mean I've lost my rights as a citizen. I still have the right to vote. I still have the right to religious freedom and to associate with people that I choose. I still have constitutional rights. The fact that I'm in a long-term care facility does not or should not limit that. And there is an exception for voting, of course. If I'm found in a separate court proceeding to lack the capacity to vote, then I may not have the right to vote. But on the grand scheme of things, we assume that people have the right to vote unless that has happened. They have the right to respect and dignity, and as we would want for everyone that we work with. The right to privacy, and that's within their treatment, within interpersonal relationships, within personal and medical records. And the right to care, and I always like to add to quality care. They're paying for care, and that care should be quality. They have the right to associate with any person of their choice and to uncensored communication. So the facility should not be opening their mail and limiting who comes in to visit. There are, of course, exceptions, as with every policy it appears, but there are exceptions as to when the facility can limit access and visitation. So just know that, but we're fully aware of that, and we work to make sure that those exceptions are the exceptions and not the rule. They have the right to personal property in their room, and they have the right to manage their own finances. It shouldn't be assumed or presumed that they don't have that capacity just because they're in a facility. They have the right to information and to participate in their treatment decisions. It should not be the facility deciding or the physician deciding or a family member deciding what type of treatment or medical care that person receives. It is their decision. It is their right to make that decision, unless they have a guardian or an attorney in fact for health care. Like I said, there's exceptions for every policy. But big picture, we always presume that people have the right to make those decisions for themselves. The right of residents, I have the right to live in that facility. And if for some reason the facility decides that I shouldn't be residing in that facility, whether it's because I don't meet the level of care anymore, or I need a higher level of care, they don't feel like they can meet my needs, I'm disruptive, I'm a danger to other residents, then they have to give me due process. And that due process means a letter giving notice that we're wanting to discharge you, having the right to appeal that decision. All of those notices come to the office of the State Long-Term Care Ombudsman. And in fact, what's been happening previously is each of the local ombudsmen have been attempting to handle each one of those discharge notices as they come in. And we receive about 250 notices a year. Those are the involuntary notices that we're aware of. In some cases, the facility will do a voluntary discharge, and we may not be aware of that. But the role of the new discharge planner that I mentioned would be to handle all of those discharge notices that come in the door, talk with the resident, talk with their legal representative, let them know their rights, help them appeal if they choose to appeal, and then assist them in the administrative law hearing if they so choose or would like our assistance. They also have the right to freedom, to be free from abuse, neglect, physical and chemical restraints, the right of expression to voice their concerns without fear of retaliation or discharge, the right to apply for state and federal assistance without discrimination, so the right to apply for Medicaid if they're running out of resources, the right to be fully informed prior to admission of their rights and of the services available and all the charges that they might be charged while they're in their at that stay. Abuse is such a big part of the rights that we see, and it's not necessarily just the facility where we see these abuses occurring. It could be a family member coming in or a friend coming in from the community and abusing, neglecting, or exploiting as well. So I just wanted to give you a little bit of feel for what the law is around the abuse. And we're seeing it from staff as well as family. If we encourage people, if they suspect abuse, neglect, or exploitation, that they should report it. All you need to report it is a suspicion. You don't need to have concrete evidence that it's occurring. The reportable incidents of abuse in Iowa are physical abuse, sexual abuse, exploitation, and denial of critical care or neglect. In Iowa, as you may all know, we don't have an elder abuse law. We have a dependent adult abuse law. I say that with a slight exception because last legislative session, the legislature and the governor signed an elder abuse law, but the elder abuse law that was signed last legislative session only gives a private right of action for someone to sue civilly. It doesn't necessarily set up a whole distinct reporting system to report elder abuse. I think we're all hopeful that that will occur next year, but it was a start. It was an opening into the elder abuse arena. So currently, what we still have in Iowa is if you see or suspect abuse, or someone calls you and they see or suspect abuse, we have to fit it within the abuse laws we have. And that's dependent adult abuse. So you have to, the victim needs to be a dependent adult, and the person perpetrating the abuse needs to be their caretaker. It is not an automatic assumption that because someone is in a long-term care facility that they are dependent. So when someone calls to make a report of dependent adult abuse, they need to set out why they feel that individual is dependent. They also need to set out why they feel that person is a person that is perpetrating the abuse is the caretaker. And that's some helpful advice that we all can give callers if they have a concern about abuse. Because 9 times out of 10, what I find is people will call the intake system, they don't know the right words to say, and the case gets rejected because they haven't necessarily said the right words. And so I think it's helpful for all of us as advocates to help people know the right words to say when they call for intake. So the abuse laws relating to dependent adult abuse are two, 235B and 235E. 235B is abuse in the community, or in my situation, it's when a family member comes into a facility and commits abuse while they're in the facility. That goes to DHS. If 235E is used when the abuse in the facility is perpetrated by a facility staff member. Okay, that goes to DIA. And I've given you those numbers for reporting abuse. So 235B is mostly community abuse. If abuse is occurring in someone's own home, we go there, regardless of who the caretaker is. If they're a resident in a long-term care facility and the perpetrator of the abuse is someone from the community who's their caretaker, then we also report that to DHS. If the abuse is conducted by someone who is a paid staff member or volunteer of the facility, then that would go to DIA. But I think it's also really important to remember that just because it doesn't succinctly or nicely fit within those categories of abuse, we shouldn't just let it go. Because it could very well be that it's criminal in nature and should be reported to law enforcement or county attorneys. If I take money from Karen, that's theft. It certainly is financial exploitation also under dependent adult abuse, but it's theft. That's a criminal statute that we've just violated, as an example. It can also be civil in nature. A civil action means you basically are contacting an attorney. So Karen takes my nicest chair from my room. That's theft, but I could also bring an action against her civilly to say, you took my chair, I want money back from what you took. That's called replevin, returning what you, I either want my property back or I want the cash value of what you took from me. It could also be I'm in a facility and I don't believe you're providing quality of care. You're violating the contract that I signed upon admission. That's a civil action. So I could certainly report things to DIA because you're violating federal and state regulations, but I also could bring a civil action against you through an attorney saying, you've breached the contract and I have damages, and I want to be remunerated for the damages that you've caused to my mental and physical health type of thing. You have to have some type of damage. So, or if a power of attorney is not paying the bill, that's an action that you could bring civilly as well, saying if you've breached your fiduciary duty, and that is an action that can be brought with the courts. I will fit the new elder abuse law that passed this last legislative session kind of fits here, because what it does is it allows someone who's a victim of elder abuse to actually bring a civil action against the person who's abusing them. And through that civil action, they can get a restraining order, meaning you need to stop what you're doing, or they can get an injunction saying, yeah, you're on my bank account, but we're enjoining you. We're stopping you from being able to access the funds. So I think the new elder abuse law fits within that category currently. So things to think about. Financial exploitation, you know, if a Social Security check, if an SSI check, if a VA benefit, retirement are taken, certainly we can report dependent adult abuse for financial exploitation. We can sue criminal, or we can bring it to law enforcement's attention for theft, but we can also bring it forward to the federal government agency that administers that check. They like to know when the people they've appointed, like a representative payee, are abusing that check, or if someone who does no authority to handle that check is misusing it. And so I've given you the numbers of those contact entities on this slide. I mentioned there are 5 categories of abuse. If you're going to report it, it has to be physical abuse, sexual abuse, denial of critical care and neglect. There's also self-neglect, and then there's financial exploitation. So what do each one of those mean? Physical and sexual abuse, physical injury, of course, bruises, broken bones, things you think of, but it also can be unreasonable confinement. So you lock the door so I can't get out. Or unreasonable punishment. Again, I have a hard time with them because I'm not sure what reasonable punishment is. So, you know, you have to think about that one. It could also be assault, meaning I'm threatening to hurt you, but I don't actually hurt you. Sexual abuse, of course, is the commission of a sexual offense or sexual exploitation. Exploitation itself, so this is the financial side of things, can be found in 235B for the issues that DHS investigates. And in essence, it's the taking of property or resources of someone else, not for their benefit. Also, it can be found in 235E, which is what DIA looks at when they're going into a facility to determine if a staff member has exploited a resident. And you'll see in this one that it relates also to medication. So if a staff member takes medication for their own use from a resident, that's exploitation. It's not just taking money or property. We also have denial of critical care and neglect. You know, the basic necessities of life are being deprived. Food, shelter, clothing, supervision, physical or mental health care. And that's where some people get in the verbal abuse, that it denies mental health care. So what about a guardian, an attorney in fact, conservator or representative payee? Can they get away with this? Can they abuse or exploit people because of their legal relationship? No. Even if they argue that they can, the answer is no. So these people, guardians, conservators, payees, attorneys in fact, under a power of attorney document, are all fiduciaries. They have a legal relationship with that individual that they're serving, and they must adhere to a strict standard of care. And it's what the reward or the principal would have wanted, not what they want. And if they don't know what that is, they have to act in the best interest. A fiduciary is a caretaker automatically under the dependent adult abuse law. If someone is the power of attorney, the attorney in fact, the guardian, the conservator, payee, and they're not acting in the best interest of the ward, and we know that or we suspect it, we need to report that as abuse. So I've mentioned, this happens to me all the time. I like to talk, sorry, so I'm running out of time. Tenants have rights as well. They don't have the federal rights because they are not outlined in federal law, but tenants have rights under the state law and rules. So what are those rights for tenants? And tenants are people who are residing in assisted living programs and elder group homes. As of right now, we only have a couple elder group homes, so it may not be a real big issue, and they're traditionally on the eastern side of the state. But what are the rights of a tenant? Well, again, they have constitutional rights. It doesn't go away just because you're residing in somebody else's property. To be treated with consideration, respect, dignity, autonomy, to receive care, treatment, and services that are adequate and appropriate, to receive respect and privacy in the tenant's medical care program. So we shouldn't be talking about what their medical needs are, what they did or said, how they look. We shouldn't be taking pictures. All those records are confidential, and they can only be released with the consent of the tenant or their legal representative. They have the right to be free from abuse, neglect, and exploitation as well. To receive from the manager and staff a reasonable response to their requests. To associate and communicate privately and without restriction with people that they choose to communicate and associate with. They have the right to maintain their own financial affairs, unless, of course, there's a legal representative to manage that for them, and to present grievances and to recommend changes to policies and services without the fear of reprisal, restraint, retaliation. I will tell you, however, I know when in talking with residents and tenants many times, even though those are rights that are clearly outlined that a facility or a program cannot violate, many times the resident and our tenants are hesitant to bring their concerns forward because they fear reprisal and retaliation. And family members are the same way. The families might say, I don't want you to let anyone know about this because they might treat mom or dad differently if they think I'm a complainer. Shouldn't happen, but the reality is that is a concern to many people. So just to wrap it up, what are some of the issues that we saw this last year, fiscal year? We received 1,174 complaints. We opened 731 of those as cases. Certainly between the complaints and cases, a lot of that is advocacy and just providing of information to people. Or they may choose not to pursue it once we've given them information. But we provided 4,445 hours of advocacy beyond just handling complaints. That could be mediating things for the resident with other members of their family or the facility. 5,360 program activities, and that equates to about 467 contacts per the 12 staff of our office. I mentioned we had 5,360 activities. This just gives you an idea of what I'm talking about. We provide consultations. That doesn't rise to a case or a complaint. We participate in facility surveys, so when DIA goes in and does their survey to make sure that the license can be maintained, we participate in that. We share concerns frustrations that we've seen or encountered on behalf of residents. Certainly we provide education. This, for instance, what I'm doing today will count as a program activity for me. We also work with resident and family councils. We're here to assist residents and to provide accurate information. You'll be amazed, or maybe not because you're in the aging network, but there's a lot of misinformation out there. We choose to develop a lot of listserv messages, fact sheets, which we feel accurately portrays the rights and the needs of residents. And when we see an issue arise within facilities, we develop some type of policy and protocol or fact sheet, and we disseminate that to all facilities and all assisted living programs and elder group homes. We have a listserv that goes to all administrators and directors. So when we see an issue that arises, we develop information on it, which is accurate and appropriate, and then we send that out to everyone. But we do that on a monthly basis. An example is the one we're working on now is for voting, because with the election coming up in November, there's a lot of questions about can residents vote. So we're putting together fact sheets to help educate facility staff and residents and families. We're working with a CMP, or a civil money penalty grant, to develop educational resources that we will place in facilities. An example could be, I received a discharge notice, what do I do? Or what are my rights? What's the MDSQ, which is another piece that we work with. We discuss facilities that might meet an individual's need, but we do not make recommendations. We work with PASAR, so pre-admission screening and resident reviews. If someone doesn't like the result of that, we will assist them with the appeal. If they do get a PASAR, which recommends specific services, then we ensure that those services are being provided. I send out Office of Elder Rights memos on specific issues that I learn of through the federal government or the state government, which help educate our staff. And I send all of those to the directors of the area agencies on aging as well. So if that's something that you're interested in receiving, please ask to receive a copy of that. And we also do a volunteer newsletter to all of our volunteers to keep them engaged and interested in working with us and on the program. So kind of as a cap to this, what are the top 5 complaints that we received in our last report cycle? I just have done the big categories, not specific situations, but the number 1 complaint we received relates to autonomy, choice, and being able to exercise their rights. Second one relates to residents' care. That might be an injury, they're not responding to call lights, they're not getting assistance with toileting. The third complaint we received relates to admissions, transfers, and evictions. So a lot of the discharges that occur are here, or the fact that maybe they won't transfer me to a facility, or they are transferring me and I don't want to go. Fourth relates to systems and concerns apart from the facility. So it could very well be that some unruly family members are coming into the facility and disrupting everything, and the resident doesn't want that family member to come in anymore. And then fifth, certainly the environment and safety, odors, cleanliness. The furnishings are not up to par. I'm not getting my laundry, or I got somebody else's laundry. Too hot, too cold. You get the subject matter there. And with that, then, I know I'm almost at my time, but this is my contact information. If you have concerns, questions, would like more information, especially since I'm probably not leaving you much time to ask me questions, feel free to follow up with me. Our website for the Ombudsman has a lot of great resources on it. I encourage you to visit the website and look and see what we have. It gets updated on a regular basis. All of the listserv messages that we've sent out to facilities are on our website as well. And so with that, I'll turn it back to Nicole. Okay. And I'll give her the clicker so that she can I can turn it back to her.
All right, thank you everyone for joining us today. I'm looking, it does not look like we have any questions or comments that have come in. So I'm going to go ahead and close the webinar. Thank you again for coming, and we will see you all again in 2 weeks at 9 a.m. Thank you very much.